What legal cases established your right to claim diminished value? Imagine fixing your car after an accident, only to find its market value has dropped. You might wonder if you can get compensation for that loss. Several court cases have helped define when you can claim diminished value. These cases show how the law views the difference between what your car was worth before and after an accident, even if it's fully repaired. The first major case is Ray versus Farmers Insurance Exchange from 1988 in California. The court decided that standard auto insurance policies usually do not cover the loss in vehicle value after repairs. The court reasoned that, if insurers paid for diminished value, it could conflict with their main job of fixing the car. This case set a precedent that diminished value isn't automatically covered under typical policies. Next is Carlton versus Trinity Universal Insurance Company from 2000 in Texas. The court said that if an insurer fully repairs or replaces damaged parts with like-kind and quality items, they are not responsible for the vehicle's decreased market value. This case made it clear that the cost of repairs and the loss of value are different things. It limited the ability to claim diminished value under standard insurance policies. In Illinois, the case Sims versus Allstate Insurance Company from 2006 reinforced this idea. The court ruled that policies that only cover physical damage do not requiring the insurer to pay for diminished value. This case confirmed that many auto policies exclude this type of claim. However, in Washington in 2011, Moeller versus Farmers Insurance Co. of Washington took a different stance. The court said that because most drivers expect their insurance to cover loss of value after repairs, diminished value should be included. This case supports the idea that vehicle owners can claim for the decrease in value even after repairs. The Connecticut Supreme Court in Littlejohn versus Ilyansky clarified that damages include the difference in vehicle value before and after an accident. They said that a car might look good after repairs but still be worth less than before. This decision backs the idea that diminished value is a real and valid claim. In Massachusetts, the case Jarrett McGilloway versus Safety Insurance Company recognized diminished value as a property damage claim. This was a big step in showing that drivers can seek compensation for the reduced market value of their cars. Finally, class action lawsuits have played a role. In Washington, a case against State Farm resulted in a settlement of over $2 million for underpaid diminished value claims. This shows how legal pressure can push insurers to pay when claims are properly supported. In practical terms, if you want to claim diminished value, you often need an independent appraisal showing how much your car's market value has dropped after repairs. Some states are more open to these claims, especially against third-party, at-fault drivers' insurers. But always check your policy because some explicitly exclude diminished value. These court cases have helped shape the rules around claiming for the loss of vehicle value after an accident. They show that while not all policies cover it, you may have a right to seek compensation based on legal decisions and your specific situation.